and members of the legal profession, the leadership of SABC, Ben Gobane, and the CEO, Ralph Fisher, Atul Gupta, my Deputy Minister, distinguished guests, ladies and gentlemen. Consistent with the undertaking I made during my budget vote speech last week, it gives me great pleasure to bring our stakeholders on board and the country at large to share with everybody initiatives that are intended to enhance access to justice for all South Africans. Our constitutional democracy has brought about more and more consciousness about rights, and also the need to protect them is accompanied by growing litigation. I'm pleased this morning to release the policy framework document on the transformation of state legal services, which forms part of a very comprehensive approach to the transformation discourse that also includes the transformation of the judicial system and the role of the judiciary in the developmental South African state. The transformation of the judicial system and of the judiciary in particular would be incomplete without the transformation of the legal profession. They are the two sides of the same coin. It is in respect of both the judiciary and the legal profession that our Constitution sets the foundation to redress the legacy of the past, which perpetuates inequality, exclusion, and fragmentation that were the hallmarks of the policy of segregation of the erstwhile apartheid system. The legal profession is the source of training for professional persons to accede to important positions where they are required to perform national duty in the broader national and international institutions, including the judiciary. It is therefore necessary that legal practitioners in both private and public sector are adequately skilled, and that the advancement of women into leadership positions in society is promoted. But the lack of effective coordination of legal services in government has led to a number of operational challenges experienced across government, which includes the prescription of claims involving our government, default judgments against government, insufficient preparation by attorneys and advocates. Instead of settling matters in particular cases, attorneys and advocates proceed against instructions and consequently burden the state with unnecessary cost orders. The lack of monitoring systems over the work and outputs of attorneys and advocates, and also the inconsistency in the determination of counsel fees by the different branches of the office of the state attorney. But the key guiding principles that underpin the transformation of the state legal services are, amongst others, professional efficiency, collegiality, accountability, and value for money. There is, of course, a general outcry within the profession that previously disadvantaged individuals, the PDIs, are not given briefs, or where they receive some in rare occasions, that the value of those briefs are not commensurate with the transformation objectives that are set in our Constitution. And some of the inadequacies relating to the allocation of legal work to practitioners include that briefs are not awarded in an equitable basis. Big law firms in cities and affluent areas and white counsel get preference over previously disadvantaged individuals, and one-man practices in underprivileged areas. Women in particular are overlooked due to gender prejudices. PDIs are not briefed to perform specialized and commercial legal work. PDIs are not briefed in constitutional matters, resulting in a select few advocates appearing in the Constitutional Court more often to the exclusion of others. Many young advocates who join the bar are not given adequate work, which results in their struggling to sustain their practices. Of course, there are perceived allegations of corruption in the awarding of briefs. Other challenges are as a result of state entities and government departments briefing private counsel directly, with some of them even engaging the services of private counsel on a retainer basis. Much reliance is also placed on the reputation of success of certain counsels, and this in turn creates a pattern of briefing to the exclusion of other competent counsel of color. The consequences of all this is that white practitioners get preference over PDIs, in particular with regard to commercial law, tax law, environmental law, and other areas of specialization, and as a result, our constitutional imperatives are not being realized. All these challenges, ladies and gentlemen, come against the backdrop that the state is in fact the biggest consumer of legal services, not only in South Africa but in Africa, and its litigation account runs into billions of rands each and every year. However, it is evident that the cake is not being shared equitably among the diverse constituency of practitioners, with blacks and women trapped at the bottom of this ladder. It is therefore important that we open the doors of access to equal and equitable justice. Our proposed policy framework document, in part, seeks to remove these obstacles to access and unleash the potential of all practitioners by ensuring a fair and equitable distribution of legal work. Our principles that underpin this briefing policy is to ensure that we need to develop legal skills in the private sector through the equitable outsourcing of legal work to PDIs in particular, in order to redress the imbalance of the past discriminatory practices in the legal profession and the state. This is intended to ensure the progression of PDIs and women in particular in the practice of law, the judiciary, and other positions of responsibility in the broader community and international. This framework shall be applicable to all affected units of the Department of Justice, including the Office of the State Attorney and all its branches. Applicable also to all state entities that are subject to the Public Finance Management Act, and to all private legal firms and legal practitioners who are contracted by the state and these entities in the performance of their legal work, as Kwanaza said from the Transnet. Our basic guiding principles also for the outsourcing of legal work is to ensure that we develop core values and justification for outsourcing of this legal work. And of course, we're developing a mechanism to create for sourcing legal work and allocation of briefs to law firms and advocates from a database to be established for this purpose. The desired mechanism should also be with a view of achieving a fair and equitable distribution of legal work. This will not be based on a handful of practitioners, but a broad representative pool of practitioners who are spread across the various specialized fields of the law. As part of this mechanism, a tool is being created for setting norms and standards in terms of which the work of practitioners will be measured, as well as measuring the transfer of skills through the outsourcing of legal work. This tool must ensure that PDIs and the new entrants into the legal practice, in particular women, are empowered not only as a constitutional imperative, but also to hone their legal skills and thereby enhance the equality of their output. In tandem with ensuring the empowerment of historically disadvantaged practitioners, the issuing of legal briefs shall be aimed at promoting and facilitating the development of skills in multiple disciplines of the law, as well as to ensure an increase in the pool of expertise of Black legal practitioners, from which, as I've said, appointments to the judiciary must be made. And some of the measures that will apply when advocates are being briefed to ensure that an exchange of critical skills occurs, amongst others, where more than one practitioner is briefed. At least one practitioner must be a previously disadvantaged practitioner. Briefs to senior counsel and junior counsel should be issued on explicit conditions that junior advocates shall be actively involved in the performance of all activities. Consideration must also be given to practitioners from small legal firms who do not have the same exposure of their counterparts in the affluent areas of South Africa. The primary objective of this policy framework in the medium term is to consolidate and streamline all state legal services under a single functionary who will be appointed as head of state legal services. The head of state legal services, who will occupy a position of or that similar to that of a solicitor general in comparable jurisdictions, will be the state's chief legal advisor, who will represent the state in all civil litigation in the same way that the National Director of Public Prosecutions represents the state in criminal prosecutions. This Solicitor General will oversee the following streams of units of the state legal services: the intergovernmental coordination, specialist litigation, general litigation, mediation services and alternative dispute resolutions mechanisms, legislation certification, state legal advisory services, as well as corporate management and research. Ladies and gentlemen, and those at home, the appointment of this head of state legal services will be done as a matter of agency for the desirable consolidation, mainstreaming, and coordination of the state's legal services to begin in earnest. This will set in motion all the institutional arrangements aimed at transforming the state legal services. In conclusion, I want to thank all those who arranged this function, in particular the SABC and New Age and Transnet, for us in order to have this opportunity of presenting this policy framework, which we believe is a major milestone in the development of the legal services in South Africa. We've taken a broad step in ensuring that we do things in accordance with the transformation agenda of South Africa. Together with the Legal Practice Bill, which is going to be gazetted later today, this policy framework document will go a long way towards the development of our jurisprudence in South Africa that is necessary to advance our democratic society that is envisaged in our constitution. I look forward to a very constructive, no holds barred engagement with you as the audience and people at home who have heeded our call to be here with us this morning to witness the launch of yet another very profound policy discourse. I thank you.
Minister, thank you very much indeed. Thank you.